Welcome everyone. We're glad to have you here for this Square Books Zoom event. I'll give you time to get in your seats, so to speak, and get settled down. I think most of you know this is a Crossroads book group event. That is a series that we established at Square Books very shortly after the murder of George Floyd, as a way to use books to discuss race matters. Before introducing our host today, I'm going to mention a few upcoming events on Tuesday, June the 29th. This is a Zoom event. University of Mississippi MFA alum Megan Poland will be in conversation with Tom Franklin in celebration of Megan's debut story collection, What Makes You Think You're Awake?, which Carmen Maria Machado described as a wonderful debut. On July the 7th, we will have another Crossroads book group, and here we will have Theodore R Johnson, a former commander in the U.S. Navy and speechwriter to the Joint Chiefs of Staff. He is the author of the newly published When the Stars Begin to Fall, Overcoming Racism and Renewing the Promise of America. It is a bold, thought-provoking pathway to a new national solidarity. He will be in conversation with former Mississippi Governor and Secretary of the Navy, Ray Mapes. So that should be an interesting event. Oh. On Monday, July the 12th at 6 p.m., these are all central times that I'm giving. This will be an in-person event in Oxford at the Old Armory Pavilion. If you don't know where that is, call you, we'll tell you. There will be a Tippecanoe County picnic in celebration of Ace Atkins' latest Quinn Colson novel, The Heathens. Per Square Books tradition, Ace will be in conversation with Jack Pendarvis. There will be music, I understand, catfish, and cocktails. Bring your own chair. The book we will focus on today, and I should add is available from Square Books, is Justice Deferred, Race in the Supreme Court, where in the first comprehensive accounting of the U.S. Supreme Court's race-related jurisprudence, a distinguished historian and renowned civil rights lawyer scrutinize a legacy too often blighted by racial injustice. These two distinguished authors will be introduced momentarily by our host, and we are all lucky to have her do this today. Barbara Phillips, previously an associate professor of law at the University of Mississippi School of Law, who has an accomplished career as a civil rights litigator specializing in voting rights. Among her writings is a piece that is prescient for today, How a Targeted Triggering Approach Can Repair the Voting Rights Act. Barbara, it's lovely to have you here today. Thank you for doing this, and I turn it over to you. Thank you.
Thank you, Richard. It is wonderful to be here and to be here with my friends Armand and Vernon. I want to introduce them by asking a question about something they really emphasize at the very beginning of their book. Both of you have described this book as being personal to you. Armand, you were born in France. You first came to Mississippi in the 60s. You've tried cases here in Oxford. You've lived in Charleston, seemingly forever, and you're a legendary civil rights lawyer. How did you get here from there?
My parents were refugees, and we left France and escaped the Nazis in 1940, the same night that Hitler came into Paris. By the time we came here, my parents had spent their young lives watching racial oppression in the form of anti-Semitism in Europe. And when they came here, they saw some of the same kind of racial oppression. And they didn't like it here any better than they liked it there. And that was the background that I grew up with. So I think that's where I would start my story.
Yeah. Vernon, there's a complicated story about where you were born, but for our purposes today, we're just going to say that you were born near the segregated cotton mill town of 96, South Carolina. You are a sought-after expert witness in voting rights cases, and you're a revered historian. You are now the Judge Matthew M. Perry Jr. Distinguished Professor of History at Clemson University, and you are the Emeritus University Scholar and Professor of History at the University of Illinois. How did you get here from there?
Well, I grew up in 96, South Carolina, and my best friend was African American, and it was a segregated society. And I like to say that the only thing that separated our two homes was an unsegregated cow pasture. My mother was a person of great faith who taught me and anyone else who would listen that all people were created in the image of God and they were all the same. And I struggled, particularly in my church that I grew up in, trying to understand how people who would be so kind and good to me could have the actions, do the things they did and said the things they did about African American people. And the way we got to this book is 1980, as you know well, Barbara, with the Supreme Court case, Mobile versus Bolden, where the court had said, the Supreme Court said that it didn't matter that laws discriminated, that the effect of the law, particularly in this case, a voting law, kept African Americans from being able to elect people of their choice or have the same influence in an election as it did white people, that you had in fact to show purpose or intent, that it was intended, motivated by the idea that you would not allow Black people the same privileges and rights to vote, at which point attorneys like Armand and Laughlin McDonald, who were doing a case, turned to historians, and I became involved in that case in 1980. And Armand and I have been discussing these issues that are in that book since 1980, literally.
So the book really has a 40-some-year-old heritage.
Okay. Armand, your book covers 200 cases of the Supreme Court about race and equality. The latest one decided just last year. It's very current. Yet this is not a book written for an audience of judges, lawyers, and law students. You tell us about the courageous people who assert their rights, the lawyers who represent them, the judges who decide these cases. You also tell us about how citizen activism, Congress, the executive branch, the federal courts, all interact across time on issues of racial justice. Tell us more about the conceptualization of this book and why you took this comprehensive approach.
Because as a lawyer, I read cases, but even when you're talking in court, the cases are about people. They're about people who are fighting with each other, whether it's over rights or over money or over custody of children or over not being able to go to school. And somehow it's that personal side that brings things to life. And I decided a long time ago, when Vernon and I were talking, we would not talk about the principles of the law in the abstract, the doctrine. The doctrine comes from the cases, it comes from the fights that people have. And so, for example, one of the people that I really like in this book, and in fact, we have a picture of her, is a woman named Mary Hamilton. This is an African-American woman who came from Cedar Rapids, Iowa. She came south, and she got arrested in Alabama. She later got arrested from other places too. When she went to court, the prosecutor said, "Okay, Mary, where were you arrested?" And she said, "My name is Miss Mary Hamilton." So the point is, if it was a white witness, he would have said Miss So-and-so or Mrs. So-and-so. With a black witness, you would never, and people in the South knew this, Mr. and Mrs., you could get lynched as a white person if you called a black person Mr. or Mrs. So he said Mary. She said, my name is Mary Hamilton. He said, okay, Mary, now, she said, I will not answer any questions until you address me properly. The judge said, answer the question. She said, until I get my proper name, judge said, you're in contempt, 10 days and $50. Okay, that's a little case. Hundreds, thousands of contempt cases are decided every year around the country. People are held in contempt for all kinds of things. Playing your radio too loud, if you have a radio in the courtroom, that can get you held in contempt. This case went to the U.S. Supreme Court. And if you had asked the average person not from the South, well, what is that all about? They'd say, oh, it's some Southern custom. It's not a big deal. The Supreme Court knew what a big deal it was. And they took this case that involved just 10 days and $50, and they reversed that conviction because the Supreme Court knew that something like courtesy titles was really one of the bedrocks that a dual society here was built on. And so the fact that Mary Hamilton's story told, and I'll say it's at the end of chapter 8 in the book, it told the story of the social side of a hierarchical society, a dual society, better than any doctrine could say it. And the fact that the Supreme Court reversed that conviction, took a case that involved just a few dollars in a few days. In fact, the Supreme Court took that case, told more than anything else about what the Supreme Court of that year, which was 1964, understood about what was going on in America, what race relations meant, and what the Constitution meant. So Mary Hamilton's story told more than you could tell in I don't know how many pages of legal jargon.
Yeah, thanks. And Vernon, let me ask you, you got my attention in writing that the spirit of the 13th Amendment is at the heart of the Constitution, and that spirit animates this book. Now, when I was in law school, the 13th Amendment was hardly mentioned. It is one of what we call the Civil War amendments, the 13th, 14th, and 15th Amendments, passed a long time ago. So why is it now central to this book? And why do you say it's at the heart of the Constitution? And why is this history important to us?
I think it's not only central to our book, I think it's central to democracy, Barbara. Some of the things that you've written that I have learned from inspired looking at the 13th Amendment this way. We all know that the 14th Amendment has now been read with neutral language. It doesn't speak to a Black person or a white person. Therefore, and medical schools and white people are suing under the 14th Amendment. But the 13th Amendment is very, very clear. The 13th Amendment is about ending slavery. If we want to, we can go that way, but we can talk about the documentary 13th, which is minor compared, I think, to what the 13th Amendment is about. It was interpreted immediately to say that it's to end all badges of slavery. What does that mean? That means everything that burdens someone who's come out of slavery for equalization. And it has not been changed. The Supreme Court has used it as opposed to the 14th Amendment and now the attacks on the 15th Amendment. It was the basis of the Civil Rights Act of 1866, the first Civil Rights Act, not the 1964 Civil Rights Act, which comes out later. So I think it is so clear of how that can still be used and the promise of American society that we owe something to people who had been enslaved. And this doesn't even go forward to say all those badges of slavery that remained in Jim Crow and some that are still there today, associated, in fact, with a group of people per se that have been singled out in the United States.
I would add one thing on that, putting in other terms, just what Vernon has explained. A lot of people think that the 13th Amendment was a one-time event. There was slavery, and it ended slavery, and it had finished the job. That's not our view at all. We think of the 13th Amendment, for just the reasons that Vernon said, as a continuing promise to end all the badges of slavery and to not be done with until that wonderful day, if it ever comes, that all the relics of slavery are done. So the 13th Amendment is supposed to be working today just as it was working in 1865. It's not done by any means.
Armand, the murder of Mr. George Floyd led to a worldwide awareness of police violence and misconduct sanctioned by the state. Many advocates focus upon the need to abolish what's called qualified immunity, which is a special protection for persons acting on behalf of the state, like police officers. You advocate a different approach to the problem, making cities and states liable for the wrongdoing of employees. Can you help us understand your proposal?
Okay. One of the problems with trying to deal with qualified immunity, and I don't have any opinion, or I'm not going to express any opinion as to whether a change there is a good idea or a bad idea, but qualified immunity deals with cases of strong abuse. And part of the problem is it seeks to put on one police officer or one government official blame in a specific egregious case. It doesn't deal with overall problems. And frankly, what we show in the book is that even if you get to trial, the jury may not do very much for you, even if you have been wrong. In every other situation in the law, if an employee does something, almost every time, the employer is the one who's liable. If you driving a car for Federal Express or whoever it is, have an accident, you're not going to be the one that has to pay. It's Federal Express that has to have the insurance and do the paying. And that, whether it's an employer or whatever, that's the rule throughout the law, and it ought to be the law under Section 1983, which is where these the qualified immunity issue arises. And so what we suggest, without trying to deal with the issue of whether qualified immunity should be changed or not, we suggest that that's only part of the problem, and the way to deal with it is to or change the interpretation of Section 1983 so that cities, counties, and states are liable for constitutional violations of their officials. There was a proposal in Congress back in the late 1970s called S35, and we say it ought to be revived.
I think that's a very valuable contribution to a very current and pressing conversation. Vernon, this one I want to ask you. There's a national conversation today about serious threats to our democracy. How does your book help us understand where we are today with respect to democracy?
I think that's something Armand and I spent a lot of time thinking about and writing about. And I do think it is a serious issue. Who would have thought when we started writing this book about race and the issues of race as seen through the lens of the Supreme Court, that in fact we would be considering once again, not since 1865 and later a Supreme Court case during Reconstruction, the issue of disunion. But we're there again in this very traumatic time. I was actually concerned about the survival of democracy when I wrote 2 books before this, The Age of Lincoln, and I noticed the similarities of our time, the anxieties of people as we were moving, from this, what had been a manufacturing base to a knowledge base and global economy. It reminded me of the 19th century and the Civil War era, when we were moving from yeoman, farmer, and craftsman into the manufacturing, and all the anxieties, the huge extremes of wealth that we had and how that influenced things, the economic recession and depression, and how at the same time some entrepreneurs were becoming more wealthy than ever. Literally, that our own age now is Mark Twain called the Gilded Age of an earlier period. We could go on and on and on, but I am so worried, and I think Armand shares this, that one of the issues is that you have to have something to bring people together. Abraham Lincoln's first real major speech was called the Lyceum speech. He worded, on the one hand, you have anarchy. On the other hand, you have authoritarianism and dictatorship. And it was his belief in the Constitution and the rule of law that would be the only way to sort of make a society work. And it goes, I think, not only the crisis in the law and the crisis in democracy, but the crisis in education. And part of what our book is trying to do is to help people understand how the law works. Most of us are not aware, we're ignorant of how the law works and how it has, I mean, you can look at the contingencies throughout our books, throughout where a decision by one judge has set into effect incredible things going in the wrong direction or the right direction toward justice, toward making us what the Declaration of Independence and that 13th Amendment promises. I'll be quiet, I can run on and on about this, but I think this is partly what kept us going in writing this book, just how important it is in the day that we are set in, and the parallels to the last major crisis that we had. And I don't think you can underestimate that crisis today any more than people underestimated it in the 19th century.
These are scary times.
Yeah. Following up on that, Armand, you know that we've always had a national amnesia about the role that government and law have played in ensuring a dual society, one America for whites and another for blacks and everybody else. So what can we learn from the book about the role of government and law in creating these two Americas?
We've tried to give some examples, and one of the ones, in fact, this struck me, involved affirmative action. For the last 40 years, affirmative action has been debated. If we try to give preference on the basis of race, treat Black people or Hispanic people better than white people, whether it's schools or contracting or whatever, is that wise? Is it constitutional? That debate has gone on in terms of, are we going to treat Black people or people of color better than white people? Well, what we don't remember at all is that that's not the beginning of the story. The 40 years before that, from the 1930s to the 1970s, was the huge, most astronomical affirmative action program in the history of the world for white people. With housing, we poured tens of billions of dollars into federal housing programs and federal mortgage assistance programs. The Federal Housing Administration put 35 million families into homes over a period of years, almost all of them white. It created white suburbs. Laws were passed, like minimum wage laws, Social Security, and they were drafted in a way, whether on purpose or not, and that's another debate, they were drafted in a way that covered almost all white workers and excluded 2/3 of all Black workers. So for 40 years, there was an enormous affirmative action program that created a white middle class and left Blacks and people of color of other kinds pretty much out of the picture. That may not tell us exactly how we ought to deal with affirmative action today, but it's crazy to think that affirmative action started with trying to help people of color. It did not start there. It's a catch-up game, and we cannot forget what went before.
And I want to add too, is affirmative action as people think of it today, not the historical affirmative action for white people only. It was not treating minorities and particularly Black people better. It was doing something the 13th Amendment promised, which was in fact to give an equal opportunity to get rid of those badges of slavery. So when we say better, I don't think we mean that it's unequal at all. It's given an equal or playing field. That's certainly the way I think Lyndon Johnson, as president, understood affirmative action.
when Abraham Lincoln was president after the Civil War, or in that brief period near the end of the Civil War, there were efforts to do something for the 4 million slaves who were being freed, to make sure that they weren't just turned out and left to fend for themselves. When Andrew Johnson became president upon Lincoln's assassination, that ended. That was a time that things might really have been different in our history if it hadn't been for that.
That's right. Vernon, Armand has told us about Miss Mary Hamilton, someone he has come to admire, one of the people in your book whose story grabbed his heart. Tell us about someone who grabbed your heart and your admiration.
Well, there's so many, Barbara, you know, and you can rattle them off who we've lost recently: John Lewis, C.T. Vivian. One that really touches me here in South Carolina is the Reverend Delane, Joe Delane Sr., who was a minister in the AME Church. And we think of Brown v. Board, people think of Kansas, but really the case that Thurgood Marshall argued, the case that started it, that I agree with John Edgerton, it should probably have been called, instead of Brown, Delaney or Briggs, because this was we discussed some of the reasons why it probably wasn't. But what this minister put up with, his church was burned, his home was burned. He had to hide in the trunk of a car to get out of South Carolina. There was a warrant for him. And yet he loved South Carolina. He came back as close as he could. When he died, the warrant was still there to Charlotte, North Carolina. But what an amazing story and courage. And all of those people in Clarendon, these were not wealthy people. They aren't celebrated. People don't know about them. They risked everything. And it was almost the entire community. These were farmers and workers who depended a lot on white people, and they lost all, and they were willing to do it because it was the right thing to do for their children and the right thing to do to get rid of those badges of slavery and to change America. And it's out of that case that not just Brown v. Boyd, but the Civil Rights Act of '64 that led to things that we take for granted today, against ageism, against LGBTQ people, for Native Americans and others, all with these courageous parents down in a small rural South Carolina community. But there are so many. Do I have time to tell one story about Mississippi and C.T. Vivian? He told me.
I guess you do.
Okay. I love this because you talked about Mississippi and you're in Mississippi, and C.T. Vivian, as you know, was from up near where I taught 34 years, University of Illinois, and we became pretty good friends. And he's told me the story one time that God called this minister and he said, "I want you to go to Mississippi and work for racial justice." And the minister said, well, God, Mississippi is a very dangerous and scary place. And he said, "But if you'll go with me, God, I will go there." And God replied, "Well, I'll go as far as Memphis." It says a lot in its own way as a story. Armand put that in the book about what these people faced. How many people were killed, tortured, so much happened there.
Yeah. Armand, let me turn to something that I think we all need to think about, because the book you all have written brings alive not only the people who are behind the term plaintiff, but you bring the judges to life too. And a provocative theme in your book is the notion that judges have choices. And the question is whether a judge reads particular constitutional amendments and laws for the most they can be or the least they can be. You present this theme as an important guide throughout the book. So say more about that.
I think that really is the heart of how to look at cases or courts. In the late 19th century and early 20th century, the Supreme Court was reading all the three, what we call the Reconstruction Amendments or Civil War Amendments, for the least they could be, unless you were a corporation, in which case they would read it for the most, and the civil rights laws, they just trivialized them. They found every interpretation that just watered them down. Later, starting in the 30s and the 40s, not just the Warren Court, but starting in the 30s and 40s, and during the Warren Court period in the 60s, 50s, and 60s, the court started reading the Equal Protection Clause, the First Amendment, for the most they could meet. And they really put some content into them. And the civil rights laws that were being passed, the Warren Court interpreted not only the new laws broadly, they went back and did a redo of the Reconstruction laws and brought some of them back to life. And now we are seeing, for the past 40 years or so, we're seeing a court that takes the opposite position again, that reads civil rights laws and the Equal Protection Clause and so forth for, again, as little as they can be. Yet the same justices today often read the religious clauses or the right to bear arms. They read those for the most they can be. So judges have a lot of choice. And one of the things we wanted to bring home to the general reader who's not a lawyer, a lot of people tend to think, well, the judges have decided this case. That's what the law means. No. The law can mean a lot of things. The same words can mean different things in different contexts. And so judges have choices. And that means when we look at a case, we need to evaluate that case by saying, this judge had a choice. Did he or she make a choice that's faithful to what is behind that constitutional provision, to our free democracy? Or is it something that waters it down? And that's what we think. That's why choice is so important, and making sure that the average citizen knows that judges are not simply dictated to by the words, but make choices. That's an important thing for people who are not lawyers to know, and even some lawyers may not be aware of it.
Yeah. Vernon and Armand, we were talking a little bit before we started that today is the birthday of Joaquin Avila, who was a fantastic voting rights gladiator with the Mexican American Legal Defense Fund. And with everything going on around voting rights issues today, we can't close this down without talking about the Voting Rights Act. So Vernon, the first time the Supreme Court considered the constitutionality of the Voting Rights Act of 1965, it approved it and recognized that it was constitutional and recognized that the vote is the most effective way to secure equality of treatment and rights. But in 2013, the Supreme Court struck down part of the Voting Rights Act as unconstitutional. And within hours of that decision, as your book notes, the floodgates opened as Republican-controlled state governments, including Mississippi, moved quickly to suppress minority voters with all sorts of new laws, including criminalizing providing food and water to people standing in line to vote. So what happened?
I actually think what happened goes back to, for me, in 2003, I was in Texas on the stand testifying. A judge turned to me and he said, Dr. Burton, and some other, he says, how can democracy continue? We cannot get young people to vote. Young people don't vote. How is democracy going to work? What are we going to do? We have to have young people voting. The next time I was on the witness stand in Texas, it was against the Texas voter ID law, which, as you said, which had just come back after the federal courts had found that, in effect, it discriminated. And the minute that basically the pre-clearance was returned, it came back. And I said, the last time I was here, a judge who identified himself as a Republican was asking me, how can we get people to vote? And now I'm here testifying in a case in which people are the state of Texas trying to stop people from voting. What happened? And I think there's several things that happened. One is the election of President Obama with a candidate that people could identify with and their interests. Minority, particularly African Americans, came out to vote and registered to vote in record numbers, something highly unusual. Similar thing happened with Jesse Jackson in South Carolina Democratic primaries earlier. And I think that was a wake-up call to people. But then secondly, about that time or earlier, people became aware of that Texas itself, and people were reading that larger than, say, the United States, is becoming a majority minority state. And those two things in particular, along with what I talked about earlier, the sort of anxiety people were feeling in terms of the changing economy, the feeling of being left behind, I think that the party in power began to attack the Voting Rights Act. Now, we laid the story out way before that, when Justice Roberts was actually working in the Justice Department. He had written memos against, of course, the Voting Rights Act, and then once there, so that as the Chief Justice has sort of been able to carry that out. But I do think the shifting demographics and the particularly awakening of minority voters excited about Barack Obama really influenced people to turn into ways to try to find out how they could reduce minority population. And of course, now it's very hard to separate out, of course, partisanship and race in terms of which party is supporting the rights of minorities and which ones seem to be, at least on the surface, against it.
If I can put in a plug for something that people could go to the internet and on a website called tpm.com, which stands for talkingpointsmemo.com. They just about a week or so ago ran an excerpt of our chapter 10, which talks about the Shelby County case, the one that threw out the heart of the Voting Rights Act in 2013. And in that short excerpt of just about a couple of pages, we go through that case and how the majority of the court really acted as a wrecking crew on destroying this law that had been so effective and was still so effective.
Yeah, thank you for mentioning that.
And we should encourage people to go to our website as well.
Yep.
With the website, with the book, there are a lot of these cases you can read, a lot of debate, and as we try to be fair and have other points of view that differ with ours on the website.
What is your website? I meant to have that put in the chat. I forgot.
Yeah.
It's called JD.
No, it's Justice Deferred, I believe.
Okay, we'll get that in there.
I'm sorry.
I think in the beginning of the book, it names the website.
Yes, at the very, very beginning of the book, on the note to the reader, has it. And then there are certain times in the notes we mentioned, but if we were smarter, we'd remember the name. Yes.
I know. I know.
Name to it when you're on the back end putting the website up.
I know.
Read, I'm sorry.
Well, we're going to get it in there so people have it, because I know that on your website there are lots of other resources that people can use to go deeper into what you're talking about in the book. So let me ask you this, Armand, and I'll ask you too, Vernon. But in the course of writing this book, which took considerable time and lots of thought, Armand, what surprises did you come across?
There were a number of times that things happened at a certain time or in a certain way that made a big difference. And one of the best examples I can think of comes in the early 1960s. The Southern states had been going after the outside agitators. They hated the NAACP, they hated Jews, and they hated the New York Times and other outlets. But they passed all kinds of laws against the NAACP, and most of these laws were so transparent that the Supreme Court had little difficulty in throwing them out. However, in the early 60s, two cases came along, one from Virginia, one from Florida, and the Supreme Court was about to rule against the NAACP in both cases by 5-4 margins. The opinions were written. If these cases had been decided that way, it could have crippled the civil rights movement in 1962. The opinions were written, they were ready to come down, and then suddenly, in the first 5 days of April, One justice had a massive stroke. Another justice had a nervous breakdown. Suddenly, what had been a 5-4 majority, there were only 3 justices on that 5. President Kennedy appointed 2 new justices. That changed the tide. If Father Time or whoever had not intervened, our history could have been a lot different.
Well, you know, there is a saying here in Mississippi that God don't like ugly. I'm just saying. I'm
hoping that's true.
Vernon, did you find? Go ahead.
Okay. One of the things was, as a historian, we looked at this, and I don't think I was really aware of it until we laid it out for the use of 25 years as a generation that Armand came up with. But we have had 12 generations of 25 years of slavery or white supremacy as the law. 12 and only 2 since. That actually gives me some hope because we made some progress. But if you think about that, when people are talking about other things, that makes a huge thing. Another really surprise was Charles Evan Hughes, the Republican candidate who ran against Woodrow Wilson for president. Until then, people had just accepted whatever the state said. And Charles Evan Hughes said, let's look at the evidence. First time. And how that began to change before the Warren Court. And then one of the other things, and there's so many, I mean, there's so much contingency in this book, but one of the others is, well, I should probably stop and go on.
Yeah, I think we do have some questions in the.
Marshall literally won almost every case before the Supreme Court, and then when he gets on the Supreme Court, he's on the losing side. I mean, it's sort of a tragic, almost a Shakespearean story. And one of the stories that tugs my heart is, you know, Strom Thurmond as a senator really grilled Thurgood Marshall, put him through incredible sort of inquiry as he was nominated for the Supreme Court. And then 1980, you have what was called the Reagan Revolution, and who is chair of the Judiciary? It is Strom Thurmond. Brennan comes up. You know, Brennan is a small in stature man, great in heart and mind, but a small built physical man. And he says, it's Tyrant Jack Thurgood Marshall. Is it true? Is it true that Strom Thurmond is going to be chair of the Judiciary Committee? Marshall assures him. And then Marshall puts his arm around him, and the 2 old warriors, these 2 old warriors for justice and equality, sort of go off like into their last battle. You can just sense the change in America that's happening there. And I think the way we told the story, we missed those dramatic changes in places.
What about Marshall leaving the court when he did?
Yes, that was going on too long, yeah. And, you know, it looked like there was no way that George Bush was going to lose the election when Marshall was very sick. He joked earlier that he planned to die, you know, on the court, never leave, shot by a jealous husband. But he was ill. Brennan had retired, and it just looked like it was that Bill Clinton had no chance. You know, of course, we didn't have Ross in it then and all. And so he retired, but he lived, in fact, into the inauguration of Bill Clinton in a few days. Right. So that would have been Clinton's appointment. Think about what maybe no Iraq war, probably because that would have determined Gore versus Bush.
No John Roberts.
The whole, I mean, that's continued.
I know. Yeah. The way things unfolded. But I think we have time for maybe a couple of questions.
Yeah, I think we do. And a little bit of that is my fault because the conversation was so good. I wanted to keep listening. So my apologies to anyone whose questions we don't get to. Okay. So this first one is from Jean. And I'm sorry, my laptop's kind of like having an attack, but I think we should be good. She says, I would like to circle back to qualified immunity. I'm not sure I heard correctly, but I thought your book focuses on who pays for police abuse or murder. Seeing the responsibility of the public employer as we do the private sector is quite interesting. However, I am unclear about what changing the onus of responsibility does to curb the outrageous police treatment of Black and brown people. And then she says, let me add that I will be ordering your book. Thank you, Jean.
Until we explain this, right?
Right. If we explain this wrong, maybe that will, no. Qualified liability of individual state officials would not be abandoned. That liability still belongs there. And it needs to be imposed in order to fix blame and focus the light on the really outrageous cases. But the outrageous cases, as bad as they are the tip of the iceberg of people whose rights are violated across the country day in and day out. And so what we're saying is that focusing on on dealing with the problem of qualified immunity in outrageous cases leaves a whole void, and the municipal liability would deal with those things. I mean, it's one thing, there's no question that a murder of George Floyd or Mr. Brown in North Carolina, those are awful things. And they focus attention. At least, thank goodness, we pay attention. It used to happen all the time, and very few people paid attention. But those things don't do anything about the day in and day out situations where state officials violate constitutional rights, and there's no remedy at all because you can't find a specific officer who has acted so badly, and the city, county, or whoever is not called to account.
Let me go beyond that and say the theory is that you have to have structural change. You don't change the individual policeman's responsibility, but if this happens enough, taxpayers and others and people who control local government said this has to stop. It hasn't been stopping, but unfortunately, as Booker T. Washington explained, you know, the color that matters in America is green. And if it costs people, we believe, like in insurance and everything else, that might force people to start doing things. There's a discussion of the case that this comes out of, Graham out of Charlotte, North Carolina, and it's tragic. But when it goes to the jury, people are always sympathetic to the policeman pretty much. And then they, you know, the actual person who's injured gets very little from it. But if we can make it about that the municipality who's employing those policemen are also responsible, we believe that there's a chance that they will start changing that structure that allows this to continue as it has.
So municipal liability is not a substitute for dealing with individual liability, but it's a necessary thing to solve a more widespread, even if not as dramatic a problem.
That was a wonderful answer and a wonderful question. Thank you, Jean. Okay, so I think we have time for one more. This comes from Riley. They say, what are your thoughts on the January 6th attack on the Capitol and Congressman Benny Thompson's lawsuit against the instigators? It invokes the Reconstruction era KKK Act.
Well, the Ku Klux Act of 1871 made a huge difference right from the start. There were, in 1 year, there were 1,200 federal criminal prosecutions under the civil rights laws, under the 1871 law and a companion law. They drove the Klan out of South Carolina. If that law had stayed alive and been used, it could have made a huge difference. That law is the same law, ironically, that comes up 150 years later. And it says it's designed to deal with exactly this, an insurrection against the government of the United States.
And we actually have an op-ed we've written. Anybody know any place we should send this op-ed about how important this act is and how it should be and can be used today. It's being used, of course, to sue the former president. It's being used against the rioters, as it should be.
Oh no, so sorry. Hi, are we all okay? That was on my end.
Yeah. It's
Okay.
okay.
Well, sorry about that. Do you maybe want to kind of start from the beginning in case, or was everyone able to hear your answer besides me? Maybe.
Armand or me, we were both talking.
Maybe we could, I'm sorry to do this, but okay, everyone heard it except me. All right, good. I will watch the recording of it. Sorry about that. So this is so funny. Did we answer the question? Or?
Yes.
Okay.
We can talk about this forever if you want to.
No, I'm sure. Yeah, that was a wonderful question too. And it does kind of, we are about out of time. I wanted to kind of brag on this book. I am not at all a lawyer, and I was kind of flipping through it earlier today, and I just love how accessible it is and the way that you kind of break it down into these bite-sized, manageable pieces. So even the folks without a law degree, I think, can learn a lot. Be a more interesting person at cocktails, a better citizen of the United States, win-win. And I want to thank you both for taking the time to do this, or really all three of you. And Barbara really kind of put all this together, put us all in touch. And when y'all were talking, I went and looked up a picture of Miss Mary Hamilton that you mentioned was in the book. And what I was kind of struck by was how young she was. And it's amazing. And I think
like with her pearls.
Yes. Yeah, I mean, how could you not call her Miss Mary Hamilton? It's so incredibly rude. But I just appreciate the tireless work that all three of y'all had done to make this a better place to live for younger generations like myself. And I find it incredibly inspiring that you have not thrown your hands up and said, I give up. And yeah, I don't know. So appreciate y'all doing this for us. And I'm so glad to our audience who joined us this evening. Little guilt trip time. We couldn't hold events virtual or in person without your support. So if this discussion resonated with you, I'd encourage you to please buy the book, preferably from Square Books. If you use the coupon code Crossroads on our website, you will get 15% off. If you would prefer to order online or over the phone, just mention that you get 15% off, and we'll take care of that for you. And yeah, just a treat. I so appreciate y'all writing this book, and I'm so glad to have it on our shelves and help put it on our readers' shelves.
Well, we're excited about all the people who seem to be interested.
Yeah.
Thank you so very much. And I would encourage people to read the conclusion of the book. And my favorite picture, I think, may be the first one, where I snuck in something the press didn't want me to, which was Thurgood Marshall's statement when he's coming down to argue this Briggs v. Elliott case in South Carolina, Clarendon. And he says, sometimes I get tired of trying to save white people. So, and I think there's a lot there. I love that. And
yeah. There he is, right?
By 13 or 14-year-old Cecil Williams, who sort of chronicled the civil rights movement in South Carolina.
All right. Well, it's never easy to wrap these up, but y'all have a wonderful evening. Wish we were doing this in person, maybe the next book or no book at all. Just come see us. We'd love to have you.
We really appreciate Square Books. It's a wonderful bookstore, and we believe in bookstores. So yeah, we're encouraging everyone to use bookstores.
All right, I'm gonna wrap this up. Y'all take care, and thanks again, everybody who joined us. And good night. See you around.
Thank you, Barbara.
Thank you.
Yes, Barbara. Round of applause for Barbara.
Very easy for us.
All right.
Now, if you guys go away, we're going to talk all night, so that'll be bad news.
Yeah. This is the one problem with Zoom meetings. There's no polite way to end them. So I'm just gonna do it.
All right.
Okay.
Good night, everybody.
Bye.